I'm attorney Ben Schwartz. Today we're going to take a viewer question from Kathy in Rehoboth Beach, Delaware. Kathy wrote in, she said, I have really bad carpal tunnel in both hands. My orthopedic asked me if I'm going to make a workers' comp claim, but how can it be a workers' comp claim when I didn't get in a workers' comp accident? And so I think this is a really good question, Kathy. I really appreciate you writing in with this. You can have a workers' comp claim for an injury even if the injury didn't result from an accident on the job, okay? So like normally a workers' comp claim is going to be based on injuries that you sustained in an accident that occurred while you were working, but not always. You can have what's called a repetitive use injury, and it can be something that does not come from a specific accident or a specific incident. It can be the type of injury that you get over time. You know, it can be something, I'll give you a perfect example. We had a case one time where our client was basically a cleaning woman, and she cleaned windows, and she would take the cleaning cloth and spray the cleaning spray on the cloth, and then she would use her hand to hold the cloth and wipe the windows, and this is what she did all day. And what happened was, in her wrists, she got carpal tunnel syndrome. She would never have gotten the carpal tunnel syndrome if she hadn't been wiping the windows all day. It's from that repetitive motion over and over thousands of times a day, over days, weeks, and years, and it builds up scar tissue, and it builds up small tears in the soft tissue complexes, and what you end up with is an injury that did not result from an actual incident. It resulted from a wearing away over time. That can be a legitimate workers' compensation injury. It's a little bit different from your typical workers' compensation case. I'll give you one example of how it's different. It's actually better, it's easier if you have one of these types of cases oftentimes than a normal accident. Here's one example of how it's different. If you're in an accident on the job and you sustain an injury, when you go before the board, before the Industrial Accident Board in Delaware or wherever you are, you have to prove that if it had not been for that accident, you would not have your injury. That's called the but-for test. But for this accident, I wouldn't be suffering from this injury. In a repetitive use type of situation, where you bring a workers' comp claim, at least in Delaware, you don't have a but-for standard. You have a different test. It's a substantial contributing factor test. So we're going to have to prove that those repetitive movements that you make on the job every day were a substantial contributing factor, meaning part of the cause, a substantial part of the cause in bringing about that injury. It's a lowered standard. It's an easier thing to prove than the but-for test. And so that's one way that these types of cases are different. It doesn't mean it's not a case. In fact, it is a case, and I would encourage you, if you have one of these types of repetitive use injuries, I would encourage you to contact an attorney who handles workers' compensation claims in the county and state where you were injured on the job, and learn more about your legal rights and find out if you have a viable workers' comp claim. I think it's a great question, Kathy. I appreciate you writing in and asking that question. I hope that if you're watching this video, you found it informative and helpful and entertaining. And maybe if you know someone who has this type of injury, you can share it with them and help them to learn more about their legal rights. I'm attorney Ben Schwartz. If you have a topic, a question, or an idea for a video like this, please send me an email. My email address is ben.schwartz@schwartzandschwartz.com. Thanks for watching.